Since we're already well into the 5-minute introductory period, I'm going to go ahead and introduce our speaker for today. Now, he did give me an introduction, which is in my bag. And I had intended to bring it up here so I could wad it up and throw it away, because I don't think you should be allowed to write your own introduction.
Yeah.
But Ross Hart is an attorney in Salem in the Roanoke Valley. He is, although he will deny it, one of the hardest working attorneys in Roanoke, in the Roanoke area, because whenever the court needs someone to step in and take I'm sorry, I'm hearing myself talk from my computer in the back, and it's kind of making,
For some reason.
Peter Veith is going to go see if he can turn the volume off. Don't close it, Peter. That'll shut down the whole meeting.
Yeah.
When they need someone to step in to be a guardian or to set up a guardianship for a person who has no family or has no other ability to have a guardian, they call on Ross. Ross is unfailing in his generosity in this area. He has over 40 years of experience. His father was a great lawyer and brought him in as a wet behind the ears lawyer, and I'm sure taught him everything he knows.
I just wish I'd listened more.
He listened more.
Yeah.
He has been asked to serve on a committee by the Supreme Court to reform adult guardianship law. He has served on the Board of Medicine. He has served on numerous charitable boards, including the Legal Aid Society, for which the charitable benefit of this particular meeting, the Blue Ridge, help me out here. Blue Ridge Legal Services,
Yeah.
is the beneficiary of our charitable contribution for this meeting. And none of that really matters, because the one thing that you need to know about Ross before you hear him speak is that he is probably the only lawyer in the Roanoke Valley to ever get away with flipping the bird to a judge. A story that he tells with great relish as recently as this Wednesday at our annual or at our weekly Wednesday lunch at Mac and Bob's. If you're ever in the Roanoke Valley, those of you out there in Zoom land, on a Wednesday at noon, come by Mac and Bob's right across from the Roanoke County restaurant, and you will find all of the old lawyers and a few of the younger ones.
And Beth.
And Beth, the waitress, sitting around telling war stories and swapping anecdotes, and Ross will be there almost certainly. But I think when he managed to get away with that, it sort of emboldened him. And so he is one of, I'm sure, many attorneys who he maintains mistakenly dropped an F-bomb while making a jury argument, a jury closing.
It was general district court.
Oh, it was just in general
They're
district
used
court.
to that.
He says they're used to it. But I think the judge was a little less forgiving in that case. No, okay.
No.
Well, he says not.
The judge did not fine me for that. I caught it halfway through. And second, he said, if I find you, I couldn't give you hell about it for the next 20 years.
Yeah.
All right. Well, at any rate, you're going to learn a lot about the nuts and bolts of adult guardianships from the premier, if not the premier lawyer in Virginia on this topic. And the great thing that I love about all of our VMBLA seminars pretty much is people compare us to, let me just say, that other organization that offers lots of CLEs, but far more than we do. I'm not going to name them by name, because they give Virginia CLEs, but I'm not going to say what the organization is called. The difference here is you're going to find out what it's really like in the trenches. You're not going to get the academic approach. Ross is going to tell you what to do and how to get it done.
And there might be a video about the COE.
Well, there's a PowerPoint there. Hopefully everybody's seeing. So without further ado, Ross Hart.
So if y'all have any questions for us, I'll be in the hallway.
And by the way, particularly those in this room and the local folks who know the Roanoke area, it was Judge Weckstein that I sort of finger towards. So you all can't hear me in the back? Okay. Is that better? Okay. John, if you will make sure that, talking to my wife, I said, well, I can do a PowerPoint or they can look at my face for 2 hours on Zoom. And she said, do the PowerPoint. So John, is the power, let's make sure the PowerPoint's going out over the network.
You have a good weekend.
I guess start.
Right? I forgot.
You get a chance to see it, I'm going to get my hair braided.
Or if somebody, I've got chat open, if somebody on chat will say the PowerPoint is up or it's my, okay. And thank you, Jennifer. She says PowerPoint is up. Good. John mentioned my dad, who is, he was one of those guys who, smart kid in school, skipped a couple grades in grade school, started VMI at age 15, graduated at 19, went straight across half the mountain to UVA Law School, took the bar between his second and third year of law school and passed it. And he was 20 years old. You had to be 21 to get your license as a lawyer. His license was issued on his 21st birthday. And I have picked the 100th anniversary of that as my target date for retirement. And that is October 18th, 2028. So folks, you all got about, 7 more years of me. But one thing he taught me, as lawyers, sometimes we write things too much in lawyer and not English. And in the guardianship arena particularly, we need to look at the orders, we need to look at the stuff. Who's got to read it and figure it out? Draft the order so they can understand it. And particularly in guardianships and conservatorships, banks have to understand it. And in 45 years of doing this job, I realized that banks are pretty damn stupid. So write it so even Wells Fargo can understand it. Okay. Fancy clicker thing and it will do it. Okay.
Mr. Hart, you're muted. Problem with it?
Yep.
Whoa.
Ross, you're muted. Ross, we can't hear you.
There we are. Okay. I'm sorry, folks. What, John, did you do a global mute and it got me too? That's what you say. Okay, folks, I'm sorry. Okay. All right, can y'all hear me now? Somebody on the text just shoot a yes and I'll be happy. Okay, thank you. 200 guesses. Please repeat the last 2 minutes, well, as sort of introductory stuff. Folks in here, I apologize, but I was talking about my dad, and one of the things he taught me is we need to draft our orders for people who will have to react to them, understand them, and know what to do. You can write orders and documents for lawyers, and in theory, we all know what it says. But in guardian conservatorship, those orders go out to nursing homes, banks, and I have learned in 45 years, banks are incredibly stupid. So you write the order so even Wells Fargo can understand it. And again, look to the audience. Who has to read the order and figure out what it means and act on it? Make it easy for them. And that was one of the messages my dad another thing my dad taught me is who's next in line? When you do something, who's the next in line? Who has to react to it? Who has to handle it? How can you make their job easier? You're filing a new case in court. The clerk has to take some action. They've got 10 cases. They know you have a habit of laying it out so it's easy for them. Guess whose file is going to get handled first? That's how you're helping your client. Okay. Guardian conservatorship is unique. Well, not unique, but it is among those that go on and on. Getting the guardianship order is just the beginning. There is maintenance of the case. There are reports that have to be filed. Clients are going to be coming back for questions, and it can get very complicated. You got Medicaid issues, you've got sale of real estate, other things that come up, and the good news is this seminar will help you get to the order. The bad news is it's not going to make you an expert. Okay, let's start out with some definitions. Basic definitions, guardian is in charge of the body, determines the care the person gets, where they're going to live, consents to treatment, or consents to withholding treatment if you're at the end of life. Conservator is in charge of the assets, cash, personal property, real property. Incapacitated person, someone who's found by a court to be incapable of receiving and evaluating information effectively and lacks capacity to meet requirements for their own health care, safety, or cannot manage property or financial affairs. A bunch of other definitions. That one's straight out of the code, 64-2000. And they're called the respondent until they're declared incapacitated. I use the word ward a lot, which is out of favor, but A, I'm an old dude, and B, I'm lazy. 4 letters is easier to type than incapacitated, or however many letters that has. Again, poor judgment doesn't indicate incapacity. We need to keep that in. And then, of course, there's the guardian ad litem, independent attorney, appointed by the court, or an investigator. Do not represent the respondent, represent the best interest of the respondent. Respondent tells the guardian ad litem they don't like something. Guardian ad litem says, too bad, I think it's in your best interest. That's what the guardian ad litem can report to the court. If the respondent wants their own attorney, they have the absolute right, we'll get to that. Then that attorney will assert what the respondent wants. Big difference in there, and that is a huge area of confusion statewide. Of course, the GAL does not have any authority to do anything but investigate. And I hate to tell you how many times I've gone into a bank after being appointed conservator, and they say, oh, Well, I thought Brad was the guardian. No, he's the guardian ad litem. They don't understand, again, and yes, I was at Wells Fargo. They don't understand anything. If anybody gets the hint that I don't like Wells Fargo, you're right. The good news is Bank of America left Roanoke, which is the good news for us. They're still in other parts of the state, too bad for them. My opinion is I don't do business with either one of them if I can avoid it. Okay. So we get started. Step one, you got to get your information together. Okay. In your forms package, the materials you got is about 70 pages of stuff. It's divided up into the outline. I'm lecturing off the outline, and you're better off following that than watching the PowerPoint. But behind that are the forms, and you will see that the form. I've given each form a name, and you'll see it in italics and where it is. The form asks for a lot of different information. Pretty much the information that you need to prepare a petition. And in there, they ask for family next of kin. That's very important. You have to notify family, and they want at least 3. If you can't find 3 family members, you have to certify that there aren't 3 family members available. But again, there was a movie called I Care a Lot, which actually irritated the blazes out of me, particularly the first 30 minutes, where somebody got a guardianship without having to notify anybody. Does not happen in Virginia. It should not happen in Virginia because the law says notify other people that this has happened. Of course, we need to know the assets. The assets are important. A, for the guardian ad litem, for their investigation, it gives them a head start. And second is that if there's a conservatorship and the court has to set a surety bond, it gives the court an idea of how much to set the bond for. Evaluation, there has to be a written medical evaluation filed with the court. It has to be completed by a licensed medical professional skilled in dealing with people with disabilities. Knowledge there. So, a podiatrist is a medical professional, but that isn't going to work. Nurse practitioner, physician's assistant works. Judges typically prefer an MD or a DO. Although in my experience, a physician, a physician's assistant, nurse practitioner actually spends more time and gets to know the patient a lot better. Once you got the information, you got to evaluate it. Guardianship appropriately. One thing with those forms, if somebody calls, makes an appointment to come in, send them the med cert and the background information ahead of time, have them complete it, bring it in for the initial interview. I have had initial interviews without that information, take an hour, they bring everything in, it's complete, we're in and out in 15 minutes. I've got what I need. And they have an understanding of the process. Okay. Is it appropriate? Yeah, appropriate. Is there a less restrictive alternative? This is very big now. Last year, Virginia General Assembly enacted a purported decision-making statute. In the Elder Law Academy, the Virginia Academy of Elder Law Attorneys, we're still trying to figure out what the hell that means. But it is where somebody who recognizes they need help gets someone. A power of attorney is a supported decision-making document, type of document. But the supported decision-making, there's a background agreement, may or may not be a power of attorney. we're trying to figure it out. I have one right now on my desk where sister filed for guardianship. I met with the respondent as guardian ad litem, and guardianship is not appropriate in that case, but supported decision-making is. She co-signed a loan for somebody on the car and was being sued for the deficiency, so they decided to do guardianship. And I go, no, that doesn't work. Again, poor judgment does not justify a guardianship. But again, our job before we even get to the court is to evaluate whether or not it's appropriate. Okay. On the medical cert, once in a while you get a doctor who says, we can't give this to you because of HIPAA. And HIPAA is a $2 billion a year waste of money in our healthcare system. Congress tried to legislate common sense. And, Congress, common sense is an oxymoron. You think the post office is inefficient? Congress has them beat. But anyway, when I get a doctor that does not want to release the med cert, I will tell them, go ahead and complete it, hang on to it. The guardian ad litem will come in and they've got a court order that says that this is allowed under HIPAA and you can release it to the guardian ad litem. If they still refuse, subpoena them to the hearing, they'll cooperate real fast. Doctors hate going to court. Typically historically the court has required the original certification. Now with everything being digitized, I'm finding that it's not needed as much. I always have it in my file in case the judge says so, but now that we can file remotely and upload exhibits, it's not as big a deal. Okay, conservatorship. Coming of age guardianships is a big thing. When a youngster turns 18, the law assumes that they are fully able to take care of themselves. The law followed the actual development of people. It would probably be 24/5, but I digress. The law says that a coming of age guardianship can be filed when the child turns 17 and a half. That way you can get it through the court so that there is no gap in authority for the child. And this is a child, with disabilities from, Down syndrome, whatever. It just gives a continuity of care. The 17 and a half actually resulted from a case that I had where the judge says, I can't do anything, child's not 18, still under parent control. I said, okay, and I asked Morgan Griffith to put a bill in General Assembly that you can file at 17 and a half. Then we had to amend it further because somebody said, well, it says you can file it, so that the court can enter that order prior to turning 18, and the order shall state whether it takes effect immediately or on the 18th birthday. In a coming of age guardianship, and a coming of age guardianship is anything up to age 22, which is under the IDEA legislation, individual disability education, federal law. Disabled children can stay in school until they're 22. And if they're in there has to be, of course, the schools have to document. And every 3 years, the school has to evaluate, are they eligible? That's called the triennial review. And once a year, they have to come up with an education plan. How are we going to educate this youngster for the next year? The General Assembly, the law requires that the IEP be made available. The guardian ad litem has to review it. So as counsel, you have a coming of age, you get the IEP in as part of your gathering information.
Ross, we have a question. A 14-year-old must consent to medical procedures. Is there a part of guardianship for the 14 to 18-year-olds for medical procedures?
No. That is that is in a different arena from the adult guardianship. Interesting question. Okay. Other evaluation, are there signs of elder abuse? Is somebody taking advantage? That is a huge issue we have. You wouldn't believe, actually, everybody in this room I know would believe how family members steal from other family members and how people take advantage, or the next door neighbor helps granny with the bills and works her way in. Those are big problems on the financial. If you see that, make sure the guardian ad litem chosen knows there's financial abuse, and schedule your hearing far enough in advance so that they can get a lot of documentation from the bank. Another issue we have is restriction on visits. And it is something VELA, when I say VELA, it's the Virginia Academy of Elder Law Attorneys. I've been a member for 14, 15 years. Time flies when you get old. And for some reason, they put me on the board of directors. I'm also on the public policy, the lobbying legislative committee for VELA. We are working, this is something we're working on this year, as far as how to protect people from being isolated. But at the same time, you have abusers coming in, and the guardian has to be able to protect the ward from the abuser. It's a delicate balance, and we're working on that. Yes.
What questions do you ask if the abuser might be a client sitting in your office in conservatorship?
I will run through the routine questions, but and part of it is in the Roanoke Valley, we are spoiled silly with the camaraderie we have, with the communication. And I will put when I handle a guardianship, I don't care who I represent. The most important person is the incapacitated person, and my energy is going to be directed to protecting them, period. And what I do is I will put a bug in the GAL's ear. I'll say, hey, look, there's some issues here. You need to look at this carefully. There have been a couple of times when my client has not been appointed guardian or conservator. And, it was an interesting dance, but we got it done. And again, that individual is protected. You can have a conservator without a guardian. The aging process is a bell curve. Our life is a bell curve. We start out unable to do anything. Somebody's got to feed us, change our diapers, get us dressed, do this, do that. The next thing is we can now get the bottle or the spoon more or less towards our mouth. I still have that problem. And then we can start getting our clothes on and off, picking out our clothes. We go to school, we learn ABC. It is a curve. And for those of you looking on Zoom, I am doing an uphill movement with my hands, gesture. And then, when we level off for a while, and at the end of life, we start losing skills almost in reverse order as we got them. And our mental acuity, our ability to read, analyze, and take care of assets goes before our activities of daily living and our ability to care for our physical selves. Keep that in mind. And there's several cases where I'm the conservator and the person is out there doing fine with their activities of daily living. And they're beginning to slow up, and we have to go back in on that. But, keep in mind that. Hey. Experienced lawyer can expect to spend 4 to 6 hours as a attorney, and that includes an hour or so in, going to court and stuff like that. I have a guardian ad litem at 4 to 6 hours. The times I do it, do my job in about 6 hours. Brad, what would you say is average time? Okay. Those of you out in the rest of the world, one of the members, one of the attendants here is, I've used his GAL before. I just asked his opinion. He said, yeah, 4 to 6 hours is reasonable. Okay.
How do you get paid?
Huh?
How do you get paid?
The law says that the petitioner does it, but the court can allow the assets of the individual, and 90% of the time we get paid from the assets of the individual, and the court awards the fees. That's getting paid as guardian and conservator is probably one of those advanced topics. It's not necessarily easy. Okay. Now we got the information, start preparing documents. I said earlier, draft your documents for lay people who are going to have to read them and understand. Don't go mumbo jumbo. I tell people I'm fluent in 2 languages, lawyer and English. I try in your materials, a thing called the Virginia Beach Checklist. It is the chief staff attorney for the Circuit Court of Virginia Beach and dissected 64-2000 following. Dissected everything that has to be done, item by item, phrase by phrase. If you follow that checklist, make sure you've covered all the points. You're going to be doing, 90% of what you need to do, you will have covered. Now, I will brag a little bit. Some of you remember my Uncle Jack, John Hart. His daughter is a staff attorney for the Virginia Beach Circuit Court, and she did the checklist, sent it to me, and I recognized it. There are circuit judges here in the Roanoke Valley who use that checklist, and there are judges elsewhere in the state who have seen it and adopted it. But it is, it is wonderful.
Ross,
I'll go back and read it again and realize, oh yeah, I need to start doing that.
Ross,
Yes.
I'm sorry, I missed a couple of questions as the chat scrolled by. Is it possible to seek a conservatorship without seeking a guardianship?
Yes. Okay.
And
Guardianship is conservatorship. Yes, you can. However, I always ask for both. I always ask for both. I go cover that a little bit more. But I always ask for everything. And back away from it. And then back away from it at the hearing. It's easier to ask for it ahead of time. You realize you don't need it, and you can back away from it. You do it all the time.
And then the other question was, how distantly related must one go to have notified kin if there are no close relatives?
Okay. John, you've got an echo that's making it impossible. And kill your, yeah. Okay. How far do you have to go to identify family members? Cousins is first cousins is as far as I try to go. Because there's a practical thing and there's a time, usually a time crunch. Virginia Beach checklist is in the form materials. I saw that was asked. It is about the first form in the materials, in the form section of the materials. Okay. I've got a form for the guardian petition is in there. Jurisdiction, where do you file? Well, 64-2-2100 is sort of the venue part of the code, and it is part of an interstate compact. There are only 4 states that have not signed on to the Uniform Act. And instead, if you're looking for legislative history and you have a Uniform Act, go to the Uniform Commissioner's website. They have a narrative of what they intended to do. Virginia doesn't do legislative history very often, but when they adopt a Uniform Act, that's our legislative history. You know, Peter, that's a tidbit you can throw in sometime to the Lawyers Weekly.
I'm retired.
Okay. But yeah, at any rate, once a state enters a guardianship order, that state has control. I had a case a year ago, woman ended up at Catawba, which is our, for those of you not familiar with Roanoke Valley and listening, Catawba is the state mental health hospital. It's fairly local. And it turns out she had a 1990 guardianship order. And I got into the case, found it, and I had to advise Circuit Court in Roanoke County that might not have jurisdiction right now because of that order. And the judge agreed with me. And then, you know, really clogged up things. But, you know, otherwise, just almost like in the bankruptcy code, to file bankruptcy, you have to be in the district for 6 months or a longer portion of the 6 months than anywhere else. And that pretty well holds for guardianship. You have to be in Virginia for 6 months before Virginia has jurisdiction, unless, of course, some other state has filed it. There are a bunch of other escape clauses and, you know, best interest of the individual. And it's also a section where the Virginia judge can call the North Carolina judge off record, talk about it, and the two of them decide who's going to handle it, or vice versa. But the courts are allowed to talk to each other directly, one-on-one, figure it out, and that streamlines the process. Yes?
Another question. Is a board allowed to move states under guardianship?
Only with permission of the court. Can a ward move from one state to another if there's a guardianship? And under Virginia law, cannot move the ward out of Virginia without consent of the court. And do you want to be? And how often is that violated? Daily. That's the practical effect of it. Okay, venue in Virginia. Once we found, okay, we're here. Venue is where they're located. If they're in the hospital in Roanoke City, and they, you know, but they used to they lived in Abingdon before they came here, but if they're in the hospital in Roanoke City right now, Roanoke City Circuit Court has jurisdiction, has venue. Or you can go down to Abingdon and file there. You know, if you like to travel a lot, it's up to you. If they're in a institution, permanently in an institution, they're in a nursing home here, you can file where the institution is located or where they lived prior to going to the institution. Okay, those are your venue choices, 64-2001A. A common failure, and this is something my cousin pointed out, always list what services the individual is getting. If they aren't getting any services and need them, you have to state that. And Amy pointed out that that's one of the biggest failings they have in Virginia Beach, is they don't say what's happening. So she wanted me to put that in there. And in the outline, I've got a practice point. I said earlier, always file for guardian and conservator. Part of it is, if you only do guardian and you later need a conservator, you got to do the whole thing over. If you file for guardian and conservator, you've notified the family that you are going to get a guardian and a conservator. And if you decide you really don't need a conservator right now, then fine, we'll back off. And I have a clause I put in a court order that says appointment of conservator is deferred. You know, none is appointed, it is deferred. If assets come about and a conservator is needed, the court will appoint one in summary fashion without further notice and hearing. Because everybody's been noticed in that proceeding. If they weren't noticed originally, that a conservator might be requested, and you decide you need one, you got to do the whole thing over. And I'm trying to make it easy when they come back to you. And as I said at the beginning, these things keep going on. The only thing, you know, it's like if anybody does juvenile court law, these things just keep going. Yeah, you ask for both and then you walk away. And I think my form has that in there. I left out of the outline one of the forms that you need to do. It's in the materials, but I didn't put it in the main outline. You do have to file some confidential information. You can have a social security number in the public part of the clerk's office, but it is required to be filed, so it's filed as a confidential. There's actually a form on SCOVA's website, but I've got my form in here, which I like better than what the Supreme Court did. And the medical evaluation is filed as a sealed document, confidential info. The medical information is not filed in the open part of the court records, it's filed with sealed records. The interesting thing is, in the notice to family, you have to send them a copy of the medical certification. It's sealed, but you send it out anyhow. Of course, I think I'm asking for common sense from the General Assembly. Regarding Ad Litem, yes. I have no idea. Okay, and I agree. Okay, the question is, what's the remedy if a medical certification gets filed not under seal? I have no idea. You know, it's, you know, somebody gets their hand slapped. I don't know. And I apologize and thank you. I am watching the comments as well, trying to do that, read the outline and run my mouth. But I do appreciate the, and y'all remind me again if I'm not being clear. Different parts of the state select guardian ad litem different ways. There is the petitioning attorney nominates somebody, suggests somebody, and the court enters the order, and you have the jurisdictions that have, you know, go by a rotating list. Both systems are flawed. One is the good old boy, good old friend, GAL, and the other one is, next one on the list could be an idiot. I don't like either one, but you know, it's local practice. In the rotating list, you know, where they go off the next person on the list, if you have a case, as I understand it, if you have a case that has a particularly sticky problem going in, you can tell the court, we need a specialist because we need a very experienced GAL for this. And, you know, A, B, and C, I've talked to A, B, and C, and these three have agreed to do it, and the judge can pick from there. But at any rate, the GAL is supposed to be certified by the Supreme Court to do adult GAL. That's in the enabling statute. Information's in the outline about that. A lot of times judges will not necessarily follow that. I've taught GAL courses and I'm not on the list, but I get to serve as GAL anyway. Anyway. The petition for, okay. Circling back to a problem case, as petitioning counsel, you know there's going to be a problem case. How do you get it to, and you're in a rotating list court jurisdiction. First, your petition for guardianship is probably going to recite the problems that give rise to need of guardianship. So that's going to be built into your petition if it's well drafted. Second, you know, and it's local practice. You know, does the judge want a separate motion for special guardian ad litem? And you recite it or attach a copy of the petition, or, you know, summarize some of the issues, stating here's why I need somebody experienced, and then you submit the GAL order with it. You have some jurisdictions with motions day, and you just show up on motions day and handle it. I've never been to a motions day. Closest I've ever done is the old docket call that we used to do back before I got, you know, back in the days of quill pens and the abacus. But again, it's a local practice thing. In the jurisdictions where you get to select your own GAL or nominate your own GAL, always call them, say, I've got one that needs A, B, C, will you serve? And my GAL order in the forms says I have talked to Brad and he's agreed to serve. And that way you don't have to get Brad to endorse the GAL order. It goes through, it saves about a week of getting it going rather than doing the back and forth. Notice of hearing. Once you've got everything done, you got to prepare a notice of hearing. The respondent gets it in 14-point type. Families doesn't have to do it. You can send the family a copy of the notice to the respondent, except it says, you know, if you do that, put a cover letter saying, this is the notice going to your brother Billy about a guardianship. We are sending this to you because you need to be aware that this is going on. You can do that. My forms actually have a separate notice to the respondent and to the family. I am probably, for, you know, sometime in the next year, I will probably combine them into one form and adapt them. But, you know, currently I've been doing two separate notices. In the outline itself, you will notice that the part of a notice of hearing is actually 14-point time, and the rest of the type, and the rest of the outline is in 12. Okay, and again, you've got the notices and stuff like that. Look, got everything ready. We file a petition and get underway. Talked about jurisdiction. If you're doing a case referred by legal aid, everybody here in the live portion knows that my wife is Susan Proctor. She's the managing attorney for Blue Ridge Legal Services. They act as the clearinghouse for private attorneys handling cases. And she needs people to help do some of these. This morning, she told me that right after I said, well, let's see. Should I do a PowerPoint or should I let them see my face? She said, use the PowerPoint. But at any rate, your legal aids, rest of the state, if you're interested in helping legal aid and do some of these things, contact your legal aid office and see and talk to them and see if you can get on it. Typically, unless you ask for more, most legal aids will give you 2 cases, not more than 2 cases in a year to handle. And when you fill out your bar form about pro bono work, there's some hours that you can put in and make yourself look good. Yeah. Okay. Jurisdiction. One thing with jurisdiction, if you're in the wrong place, the court can always transfer it. It's no big deal. Practice scheduled hearing. give the guardian, it depends on where you are, because some places, 21 days, getting a hearing in 21 days is a luxury. Language in the statute that it's supposed to take place within 30 days or 45 days. Local practice, we get it scheduled, give the guardian ad litem enough time to do their investigation and let everybody know what's going on. And I file a petition, my guardian ad litem, whoever the guardian ad litem is, it is open file. Come in my office and look at everything in my file, and they will take advantage of that. I try to send them everything. I send them the background information form questionnaire that I have filled out, the medical cert, the order appointing them, the petition. If the client brings me the IEP, of course, they get that. They get bank statements. The more you get to the GAL, the less work they have to do and the less your client has to pay or the disabled person has to pay for them to go out in the field to do it. To go to a bank to get information, you're sitting there for an hour while they send it off to somebody who's never been, some lawyer who's never actually practiced law, but they're sitting in a cubicle in Charlotte somewhere looking to see if the branch can give them the information. That's the GAL. So again, the more information that the GAL has, the easier their job's going to be. With the package, make sure that the court gets everything ahead of time. Again, local practice. Judges hate stuff showing up the morning of the hearing. I am guilty of it too, but they hate it. If you have there, they will have looked at the file ahead of time. The law clerk will have looked at the file ahead of time and gone through the Virginia Beach checklist. Again, get everything to the court at least a week before the hearing if you can. And if conservatorship and there is surety on the bond, you can frequently waive surety if the amount that the conservators handle is less than $25,000. Over that, call the bonding company who's going to do the surety, give them the proposed conservator's name, address, and social security number. They are going to run a credit check and make sure that that person is bondable. It is very embarrassing to get Betty Lou appointed conservator and she's got a credit score of about 300. And then you have to go back and say, Judge, we need to do somebody else's conservator because Betty Lou can't get bonded. And that's extra work for you, and you're not likely to get paid for that. Do it ahead of time. No, guardian ad litem, talk about stuff that guardian ad litem does. Guardian ad litem will do, yes.
Something a husband could do for his wife, hypothetically, like get a family trust to avoid some.
Alternative to doing a guardianship, yes. The question was, is there alternative to this? Is there something a husband can do ahead of time or a family can do ahead of time? Talking, maybe a trust, family trust, power of attorney, something like that. Absolutely. This is only because these guardianship is for those who don't plan ahead. And I'll have clients in, I say, okay, we're doing estate planning. You need to power of attorney. I said, look, you get disabled and it's going to cost $4,000 or $5,000 to do a guardianship. My power of attorney is only X. Your money. And they go from there. I said, well, I don't want to give everybody power. I said, well, if you can't trust them while you can watch them, how can you trust them when you can't watch? I digress. Huh?
comment is, and if you'll repeat this, Ross, can I suggest,
I've got it. I will repeat it. Can I also suggest as an adult GAL that you ask your petitioners about contact with APS, felony convictions, and domestic violence convictions? Elizabeth, that is a wonderful idea. Thank you very much for adding that, that comment. And every time I do a presentation like this, I get comments of stuff that, daggone, I need to add that to my repertoire. And you have just added something to what I'm going to do. Thank you very much for that comment. Yeah.
I have seen now that the Adult Guardianship nursing home doctors, mothers, deal with adult children. Elderly individuals not capable against their wishes without any legal determination of capacity. What can the elderly person do?
Well, if the elderly person, okay, the question is, nursing homes and doctors will talk to the children and almost ignore the elder person with whatever they want. Well, if they realize it's happening, they need to assert themselves. On the flip side, is it permitted? Yeah, the Virginia Medical Decisions Act, it is in Title 54, part of 54, it's under the Board of Medicine. There's some real interesting stuff under the Board of Medicine, under the section dealing with the Board of Medicine about, you know, medicine and the healing arts. And the pecking order of who can make decisions is set out in there. I don't have that cite on the top of my head. Okay. Okay, let me do this one. I'll come to you. Quick question about how is a GAL paid for services for indigent folks? You are paid at the abysmally poor state rate. The Commonwealth of Virginia will pay the fee. And you have to, the guardianship order has to have a finding of indigency, and you have to file a request. And the guardianship order will also set your fee. And then, you know, the used to be you'd have to do, I think it was a green form or something like that. Now it is online. And I don't fool with it myself, so I don't have direct experience, but yes, you get paid by the state. Yeah, go ahead.
So I serve as GA and I do the indigent fee for social services a lot, but I can never get like background checks. I mean, I don't know why they won't, I don't know where to go to get these background checks on the conservative perspective guardian or whatever, and the Commonwealth office won't run one for me. And,
okay.
Maybe you have any.
Okay. And that's something. The question is, how about doing background checks on the proposed guardian and conservator? It's not something, and it's an interesting question. Okay. It is not something that I have done with any routine. I will look at, I use my gut. If something smells bad, I'll start looking more. For conservator, I will look in the general district court online to see if they've been paying their bills and or if they've been, you know, that. Of course, they likely won't be bondable. And part of that is you talk to the petitioning attorney. And family members, part of the GAL's duty is to check with other family members, and you'll pick up a sixth sense. And if you need it, you know, we can do it. Yeah.
You can file an application with the Virginia State Police.
Yeah.
To do a criminal background check.
Okay. And another comment is you can do an application with the Virginia State Police for criminal background check. Again, it's not something, I have not seen it, needed it in my practice, but it is something, it's at least now in the back of my mind. Mr. Kohler's here telling me I need to be quiet for a few minutes and we're going to take a break. And let's see. Yeah, you can do the statewide court website for criminal matters, Pacer. Comment here, Elizabeth is coming back in with that. And, you know, check your online databases. A lot of times you can do it. Okay, John? Okay, so we're going to take about a 5-minute break. For those of you who are here in Salem, if you are already getting hungry for lunch, there are a selection of sandwiches and cookies, and I believe they put soup in the crock pot soup back there, so feel free to get up and get some now, or if you want to wait until noon. I will tell everybody, both online and here in Salem, I still have not heard from Fine Law about the presentation we were supposed to have for our lunch portion. So we may be having just a quiet lunch and ending sooner than we thought, unless I hear back from them. For those of you who don't know, Jonathan Clark, who was the longtime representative for Fine Law and a very, very good friend of the Salem Roanoke County Bar Association and this association, the Alliance, has moved on to, as a lot of people are doing now with the labor shortage, moved on to a different position. And so he was supposed to have actually been here in person, but things changed kind of quickly a couple of weeks ago. And so I hope we'll have our speaker who would actually be coming in by Zoom. But in case we don't, you know, feel free to go ahead and get your lunch now so you can get on with the rest of your Friday if we're not going to be here until 1 as we had intended. So we'll come back at 11:10 to finish up the CLE. I'm going to hand out the CLE forms here. I've been posting them in the chat already. And of course, as you all know, you can submit those online now. So we don't collect them like we used to years ago. I know a lot of people here probably remember just being able to fill them out, hand them in, and not worry about getting their hours submitted. But the bar would really prefer you do it online, because it cuts down on their having to, you know, open your envelope or get your fax and then put it in the information themselves. I will tell you, the ladies that I work with at the MCLE bar, they are some of the hardest working civil servants I've ever seen. And so anything we can do to make their job a little easier, I'm sure they appreciate it. So we'll be back at 11:10. Thank you.
Is it cold out there?
Well, we have to, for Guardian, Guardian lighting representation.
It looks like it's breezy.
I can't say where. Yeah.
Well, I went to lunch.
Because that's, I think, if they're getting CLE credit, but they'll get credit.
Jury trial.
She said, "Mom, where are you?" I said, "Huh? Where are you?" She's been here today.
I heard you out. I heard you out there giggling. I said, "Well, they're having a good little conversation." Yeah, I didn't reach out for help. You said your friend could help you, but you didn't contact her. Friend that was your mama who helped you buy the house in the first place.
Oh, Robin. I forgot. I forgot. You did that.
They start back practice like across the street where
Keep all that from changing your perspective.
great up there.
Yeah, that's the story. So we really kind of bottom line is it, because we usually get so upset when take a deep breath, because I mean, it could potentially damaging for the tail, but at this point, it's on her. I mean, she got the ball rolling. She can stop the ball, and if not, I think an attorney will destroy her and she'll look like a fool in court.
Yeah, he's kind of connected somewhere, so.
She ought to know she done lied about that second one. And a judge will see, how in the world can you file two different complaints on the same incident and now even look like the same?
Looks like you came back and did something.
Just trying to find it.
So I'm hoping that she'll do the right thing.
Miss Hill, you're not muted.
Okay, I'm sorry. I wonder how to do that. I thought I was muted. Let me get back in.
He got
That's my mute button.
he's trying to do better. Oh, yeah. Charlie don't. Charlie's white armor secretary. He's great across the street. Yeah. And I'm thinking.
John, shall I fire back up? John. Shall I fire back up? No. Huh? Yeah. No, I'm now you say that, I remember. Somebody does that.
Okay, and I'm gonna fire up right away because
Questions, or does that make it more difficult for you?
no, questions make it more fun for me. Okay, John, I think I've got that. I got the question. All righty. Folks, I'm going to fire back up because I've got 50 minutes to finish running my mouth. At the hearing, we're going to start up with going to the hearing. You know, as always, typically we go into a hearing, we've got a sketch order ready to go. Oh, let me circle back. There's a question about ward moving states. And it requires court permission before a ward can move from one state to another. And the question is, can you put it in the order of appointment? Absolutely. I have done it. I had somebody, I was guarding Ad Litem, the individual's here in Salem, the case was in Warrenton, and the individual's going to move to Atlanta, and we wrapped it all up into one order. And, you know, did the whole thing. If you do get a case about moving from one state to another, holler at a member of VALA. We have forms, and VALA is more than happy to share this stuff or at least point you in the right direction. Okay, back into the order. You know, every case is different. I have a sample order in the materials. And make note of 64-2009E, special required language in the order. The General Assembly added that in 2020, I believe. And, you know, address the various issues. There are a couple of things the General Assembly put in there. They were reacting to a particular case or series of cases in Richmond, and you know, a couple of special issues to address in the order. Voting. Does the respondent retain the right to vote? I have some judges who would say always, and I have other judges who say never. You know, a good lawyer knows the law, a great lawyer knows the judge. It ain't because we're drinking buddies, it's because we know what their hot buttons are. So again, look at, you know, what does your local court, the judge hearing it, what is his preference? I typically default to maintaining the right to vote. Even if they're crazy, they can't be worse than most of the voting public. And address any issues that come up. Estate planning. If you're asking the court to approve special estate planning, do it as a separate proceeding from the guardianship, tied to the guardianship. One of the big complaints my cousin has had is people just sort of say estate planning and without the required notices. If you're doing estate planning and a guardianship, extra notices are required. You know, on real estate, you can give, the conservator can be given permission to sell real estate in the initial order. I never put that blanket permission in up front. I always have reserved the right to get the court to approve it. It is an easy process. You can give me a contract today and good chance I'll have an order entered by next Friday approving the sale because of the way I reserve it in, you know, preserve it. Here is why. Mama's lived in the house since 1960. Its maintenance has gone to heck. The kitchen is as modern as the day the kitchen was put in 1950 when the house was built. The city thinks city does a tax assessed value as if it's got modern appliances and stuff. It's, you know, it's got galvanized piping. It's got, you know, knob and tube wiring. I mean, it's got all sorts of problems that detract from its value. If you sell it, if the person is going to go on Medicaid to help pay for the nursing home, which is a huge percentage of these cases, and if the property is sold for less than tax assessed value, Medicaid will penalize the respondent for an asset being disposed of at less than fair market value. Medicaid says the tax value is the fair market value. There are two exceptions to the rule. Exception one is if you get an appraisal. Actually, there are three exceptions. Exception one is if you get an appraisal and then you sell it for the appraised value, if it's less than the tax assessed value. Number two is if the sale is approved by the court, and that's the cubbyhole I like to get in. The third one I don't like so much. If property is lost to foreclosure, it's not considered an uncompensated transfer. But always reserve, and again, local practice in the 23rd Circuit where I am, and those of us in the room are pretty much, we go back to the judge to approve the sale. In some parts of Virginia, the sale has to be approved by the Commissioner of Accounts. Talk to your Commissioner of Accounts. If you're doing one of these in a Commissioner of Accounts jurisdiction, talk to the Commissioner and find out how he likes that authority put in the order. If you track, some people will just cut and paste out of the Virginia Code, which is, it slows down the approval process by 2 months. You're selling the property, you have a buyer, they want to move in, and you're telling, well, it's 2 months before we can get the sale approved. You've lost a buyer. You need to think ahead. Don't cut and paste, read it and understand the mechanics. How does it operate when we get finished? Incidentally, the hearing does not have to be at the courthouse. The court can convene if somebody's in a hospital and you want to have the hearing at the hospital. The court can go to the hospital. Try it. The judges will remember you fondly for that. Hearing. Threshold issue is capacity. Period. Does the person have capacity or not? Is the incapacity proven by clear and convincing evidence? If so, then what are we going to do about it? The hearing, I have a memo that goes to my clients that says, okay, the hearing is coming up. I have, here's a question I'm going to ask. And typically, a retired judge from this area told me, Ross, always put that evidence was heard or tenus. That means there's no transcript. The judge heard the evidence and made the findings of fact. And you read my order, you're going to see detailed findings of fact in a numerical order, numbered paragraphs. But that way, if it goes on appeal, the court's going to look ore tenus. The judge heard it and made these findings based on the documents and a warm body testifying. What does a warm body have to testify to? Darren, you've read the petition. Is everything in it true and correct to the best of your knowledge? Yes, thank you. Any other questions? Yeah. He testified. The petition's correct. Yeah. I'll actually do a follow-up question. And I've got some in the outline and stuff, but sometimes do a follow-up question. Well, how's Irving doing today? Well, it took us an hour to get breakfast in. Okay. Yeah. Some little snippet like that. Once you've got the order entered, the easy part is done. Okay.
Wants to not be beneficial or they're in a nursing home.
Respondent has an absolute unqualified right to be present at the hearing. I had the hospital load up an ambulance with the gurney and bring them into the courtroom. So the question was, what if the respondent wants to show up and they physically can't get there? Well, they can get there. They have the absolute right. Of course, picture somebody laying there in a hospital bed in the courtroom saying, Judge, I'm good. I can take care of myself. All right. Now, once the order is entered, of course, you got to get the client, review the results, say, yes, you got to, here's what's happened. Duties and reporting requirements, they have to file, as guardian, you have to file a report to Department of Social Services in 4 months or 6 months, and you have to do that annually. That report is in the process of being changed by the Supreme Court of Virginia, as John indicated. I got appointed to what they call the Wings The Chief Justice, I get a letter from the chief saying, would I be a member of the Wings Commission? And I'm smart enough to know that you never say no to the chief. And so I've been on it. I am about the only street lawyer on this thing, but at any rate, it's something we're working on. Is upgrading the report. The conservator has to file an inventory of what they have within 4 months and do the first accounting, file it within 6 months. And I give the client, I have a thing called top rules for conservators. It's in the materials. It's a top 10 list, and I tell my clients, if you follow these rules, you will stay out of trouble. And of course, by the individual staying out of trouble, the incapacitated person, the ward, is protected. If you want your clerk to think kindly of you, get them everything you can ahead of the hearing and schedule an appointment. Again, local practice, but schedule an appointment for your client to qualify 30 minutes or an hour after the start time of the hearing. Let the clerk know that as soon as the hearing's over, you'll be over there. If they've got all the information, they can get it typed into the computer, and the appointment only takes 15 to 20 minutes instead of an hour. And the clerk doesn't have, how many of you had been typing something for a client with the client sitting there? It's kind of nerve-wracking. You're punching away and they're kind of, don't know whether to say anything or ask questions, and you're trying to get something done. Well, clerks have that thing too, and they love being able to put stuff together without people watching. So you get them the stuff ahead of time. And I think the form, I think some of the information form is in the materials as well that I use to send them. My practice is to, I should have a cat, but anyhow, I have a laser. Pointing at something on the screen, but basically part F is what's on your screen now. I schedule automatically 2 appointments for my clients after the hearing, after they qualify. I schedule one at 2 weeks afterwards. They're getting into it. They've encountered some issues with the bank. They're going to have questions. That is the most valuable meeting post-hearing that I have with them. I'm helping them out with the questions, and that'll frequently take an hour of time, and add that to that 4 to 6 hour time. If you're going to, particularly if you're doing a flat rate, but be able to answer their questions. How do I do this? Wells Fargo's giving me crap about that, and then 2 months, and this should be 2 months after the 2-week hearing, so it's actually 10 weeks after the guardianship hearing, the appointment. They're getting ready. If it's a conservatorship, they're getting ready to file their inventory and other reports, and you can help them through that process.
Find the bondsman. Is the clerk giving you a list or?
It's in Roanoke, there's only one. Call me and I'll give it to you. Okay. Find out who handles surety bonds, probate and surety bonds in your particular area. Ask around. Actually, there are 2 of them, but I only use one. Okay. Common is it the guardian conservator the same person, and is it permissible? It is extremely common and very permissible. Sometimes it's split duties. Most of the time, it's actually more convenient that you have one person handling everything. Are there issues if guardian or conservator have multiple wards? I hope not, because I've got a whole bunch. And I've got colleagues around the state that have a whole bunch as well. You have to be able to manage it. In my office, managing a guardianship at my billing rates, and it's an adjusted billing rate I do not charge my lawyer rate for acting as a guardian. Okay, I charge a reduced rate because you don't have to be a lawyer to be a guardian, and I charge a reduced rate. It's still a rather large rate, but and as a conservator or fiduciary, you don't have to be a lawyer to be a fiduciary. You just have to have to understand that. I have a different rate for acting as that. Applying those rates, average guardianship in my office at my billing rate is worth about $250 a month. A trend in the Roanoke in the 23rd Circuit is we are building in minimum fees for guardian and conservator, particularly for those of us professionals who take it on because there aren't enough people to do it. The Virginia Public Guardianship Program has slots for it's about 1,000 people across the Commonwealth. The waiting list to get a public guardian is 6 months or more. And they can be selective on it. They really don't want anybody who is living in the community simply because it's a heck of a lot more work for them. By the way, the Public Guardian Program, the agencies that act on the Public Guardian Program get paid $5,500 per year per guardian that they handle. The caseworkers are limited to 20 guardianships, 20 people at a time, although in an emergency they can do as many as 25. Okay, cool. Okay, there's a question in here about contested guardianships, a urination tournament about who gets to take care of mama. And that is beyond the scope of this one. You've gotten into a contested, and I could go on for 2 hours about that. The courts, if two separate petitions are filed, astute counsel will get it consolidated, and judges will want it consolidated, and you get everybody in the courtroom at one time. And all, but yeah, the judge will sort it out. And a lot of times you get contested, get children contested. I remember one case 20, 25 years ago, the judge looked at the $2, says, I don't like either one of you. I'm going to get Ross to do it. And one day I was visiting in chambers and I said, Roy, can I speak freely? Yeah. What did I piss you off about that you stuck me in this daggone thing? And I probably shouldn't have said it that way, but that's what I said. Yeah. Anyway, he laughed. It was that bad of a case. Okay, other issues, counsel for respondent, absolute right. It's optional, absolute right. Ad Litem needs to certify that none is needed or requested. That has to go in their report. Real estate, local practice differences, that a few minutes ago. Driving, Virginia law now says the court can allow the individual to continue to drive, but the individual has to pass driving tests by DMV. Guns, forget it. If you were declared incapacitated, federal law, state law says no guns, period, end of paragraph. Voting, I covered that a few minutes ago. Terminating a guardianship. Of course, you can always get removed by the court. When somebody else is appointed, the word dies, and the word dies, the conservator manages until the estate takes over. If it's a small estate, then you've got the Small Estate Act in Virginia. Concluding, this quicker than I thought. You don't want war story. Well, okay. This is not supposed to be litigation. We are fixing a problem. This is on the chancery side of the court. Now, we have unified pleadings, but we still have a difference between law cases and equity cases in Virginia. We just have a unified pleading. We did not get rid of equity. We did not get rid of law. And there's a lot of people that have lost sight of that. I'm a chancery lawyer. You take your chances if you are. I am a chancery lawyer. I work on the equity, I work more on the equity side of the court. Again, I've got my time estimates here, and the post hearing and stuff like that, here in conclusion. If it is litigation, contact, I'm a Vela, the Virginia Academy of Elder Law Attorneys. I've got the, they're listed in the outline. There are about 200 of us. There is more work out there than we can handle. Frankly, dues I pay to Vela is probably the best money I spend every year. A listserv that if you have a problem and put it up there, odds are somebody's encountered it, will give you the answer. If somebody has a form, they share the form. It is just the friendships that we have, the camaraderie we have all over the state. It is incredible. To be in Vela, you actually have to join the National Academy of Elder Law Attorneys and then pay an extra chunk of money to join the Virginia chapter. If you join right now, the rest of this year is free. Dues are calendar year basis, and if you join right now, you'll get 15 months for the price of 12. We're in the last 90 days of the year. But if you go to Vela, the website here, that'll take you to the national. You can sign up. You can look at some of the stuff we do. We have an online database for members only so that you can find stuff that's downloaded, that's put in there. I will humbly admit there are one or two of my forms up there. Yes?
You mentioned voting, but other than politics, if the board owns a stock in a family closely held corporation, who gets to vote their stock shares?
The conservator. The question is, in a corporation, close family held corporation, or even a public corporation, who votes the ownership interest in that? The conservator. The conservator does that. All right. Coming attractions. Here's what's coming down the pipeline. I talked about supported decision making earlier this morning. Again, we're still trying to figure out what it is, what it means. It's one of those, a bunch of ivory tower academics have decided that this is a great thing, and they have no idea how to put it into practice. I have looked at forms nationwide, and they are less than helpful. So I'm having to invent my own on a couple. JLARC, Joint Legislative Audit and Review Commission, arm of the General Assembly. They have been asked to study guardianship law in Virginia and suggest changes. Their report is due out in 18 days. It's due out on my daddy's birthday, October 18th. And they have been talking to a whole bunch of people statewide about what they see in it. They have had to endure about 3 hours of talking to me about what I see. They came to the Wings Commission, one of our meetings, and talked about it. And they said, well, they've talked to this people and that people. And they were talking to the academics and stuff, and no lawyers on the street. And I gently pointed out that omission. And so they called me, and I've given them other lawyers across Virginia to talk to. They've talked to about 6 or 7 street lawyers about how it works in real life, and they've certainly heard from me. Let's see. Okay, I need to fill 8 minutes. Okay. Congress. Yesterday, Senator Casey and Collins on both sides of the aisle jointly introduced some legislation in the Senate that will affect guardianships. There's been other legislation introduced. You know, Congress is getting into the act again. Britney Spears is influencing this, is driving it, and in Senator Collins' press release, she talks about the Britney Spears case. And it's, you know, it is in the national spotlight. How many Star Trek original series fans have we got? Okay, I see a bunch of people on Zoom raising their hand as well. Lieutenant Uhura, Nicole Nichols, is subject to a guardianship, and that is generating some publicity, not to the extent that Brittany, but she is a subject of a guardianship as well. Yeah, our population is aging. You know, people are taking bets when I'm going to be the subject of a guardianship. And, you know, so it is happening. Part of it, of course, is making plans ahead of time. Best service we can do to our clients is talk to them about the hassles of guardianship and make sure they have something in place that will avoid it. A very strong power of attorney with accountability and somebody that you trust. When speaking about power of attorney, a lot of people say, well, I want a springing power of attorney. I don't want to take effect until I'm disabled. Well, if you can't trust them while you can watch them, how can you trust them when you can't watch them? I do not do a springing power of attorney. It's my personal practice. And then, of course, there's the Wings Commission, the Working Interdisciplinary Network of Guardianship Stakeholders. It is a cross-section of any discipline in Virginia that gets involved in the guardianship process. We've got Adult Protective Services. We have nursing home administrators. We have hospital, county attorneys, Commonwealth attorneys, Adult Protective Services, I said that. We have court clerks. There are 4 judges on Wings. In the 23rd Circuit, Judge Carson is a member of the Wings Commission. Judge Simmons in Withville, in Marion, Judge Hall in Tidewater, and Judge Willis in Fredericksburg are the judicial members, judges that are on Wings. The DARS, Department of Rehabilitative Services, whatever it's called. I know the acronym and I can't spell it out. Got 2 or 3 folks there in it. The Public Guardian Program is there. Again, I am probably the most active street lawyer doing this stuff out of these 30 people. But it is there, and we are getting a lot more active, and we can see some stuff coming from there. Okay, there's the jury. Yeah, I have not personally done. The question is, have you participated or know personally of a jury case for contested guardianship? Any insight you can offer? Well, in occupied Virginia, excuse me, Fairfax, Northern Virginia, they've had several jury trials, and VALA members have done them and forms. I got a call from one of the judges on Wings because they had a jury trial coming up in their neck of the woods. I said, daggone, how do we get instructions? Well, if anybody knows how to get instructions, can I call Ross? Okay, all right. So I get a call, help, and I said, well, I haven't done one, but I know who did it. And the VALA listserv, I put something on the listserv. I said, here's what's happening. I have a judge who's called wanting to know the jury instructions and how to do it. Of course, I didn't identify the judge, and I won't now. You know, I got responses. They pointed me to a case, 1 or 2 in Fairfax, and in fact named the judge in Fairfax. And I relayed the instructions and everything. I relayed to my friend, and also said, call Judge so-and-so in Fairfax and talk to them about it. You know, so we were able to connect it. Again, Wings, you know, I mean, the VALA connection helped out there. I have not done one, but you know, call VALA. if you go to the VALA website, there's Find an Attorney, and put in your zip code. Use your zip code to find it. Find one, and it'll give you the VALA lawyers within a 25-mile radius, although you can expand the radius out. And look at that. If you click on their name, you get to the website, and you can see, okay, here's somebody who can do, you know, or shoot me an email, and I'll let you know who's done a jury trial. Okay, comment, and it's an excellent comment. We'd like to see some of our focuses on guardianship issues for persons with mental illness, advising family members who are trying to get these guardianships to protect spouse and children. Very difficult to get, usually involve young adults. Britney Spears, different experience for those, and unfortunately it's scrolled off and all that, but yeah, it is something, again, that's specialized. That's the kind of seminar we do in VALA. We have focused seminars, you know, focusing in on different aspects of elder law. Again, what I'm doing this morning is 2 hours, very broad brush, get you started, and in part let you know how complicated it is. And John is telling me that I have
reached your roundup time, so if you're ready to stop, we can stop.
Okay, let me see, Q&A, and again, I'll leave it with one of the VALA slides.